Hello and welcome to today's episode of Stand Up, where I'll be joined by constitutional law professor Eric Segall of Georgia State University to talk about the upcoming term at the Supreme Court, the big cases, as well as his piece on how to reform the court. A great conversation with Segall, as always. And if you want to skip ahead, that begins at about 14 minutes, but you do not want to miss this news update, including a robust look at what's going on with the UAW. If you're listening on Wednesday, the 27th of September, which is when this episode dropped, happy birthday, Julia. My daughter, Julia, 16, getting her driver's permit today. If you have any advice on how to teach a kid to drive, send it my way. Of course, I did it with Ava. She's been really good, but any reminders you have, I'm all ears. Just a few days left of September. I don't even think I welcomed you to autumn. My fault. I don't know why I'm the autumn welcoming committee, but it's, of course, one of my favorite seasons of the year. It seems unoriginal to even say it. Either way, welcome to autumn. Welcome to Stand Up. Very happy to have you joining me today. A few folks have reached out to me to let me know that they will be at my show October 11th in Pittsburgh, Pennsylvania, where I'll be co-headlining a stand-up comedy show with J.L. Cauvin at the City Winery in Pittsburgh. So maybe you'll be added to the list and we'll all have a little party. Looking forward to that. Also later on today, I'll be dropping a conversation with hopefully the next governor of Montana. Our friend Ryan Bussey will join us. And tomorrow I'm headed up to New Hampshire to speak with the New Hampshire Democrats. Then I plan to host the hangout from my hotel room there in New Hampshire, so I hope to see you then. All right, let's get underway with a little bit of a news update before we get to Segall, and it's day 980 of the Biden presidency. And yesterday, the Senate announced a bipartisan deal to keep the government open through mid-November and provide $6 billion in assistance to Ukraine. We'll see what happens with the House. I think they're likely on track still to shut it all down. But the Senate, for its part, doing its part somehow. Mitch McConnell getting it done. For the second time in 3 months, the Supreme Court rejected Alabama's request to use a congressional map that includes only one majority black district. So I talk about that with Segall in today's conversation, and now it has happened. Alabama was rejected for the second time in 3 months, so it's a bit moot what we talked about, but still, he lays it out pretty well as to what's at stake, so I don't need to go into detail here in the opening. The Federal Trade Commission in 17 states are now suing Amazon, and big news in Trump world, a judge ruled that Trump Jr., Eric Trump, and the Trump Organization, here it is from the New York Times, a New York judge ruled on Tuesday that Donald Trump persistently committed fraud by inflating the value of his assets and stripped the former president of control over some of his signature New York properties. The surprising decision by Justice Arthur Engoron is a major victory for Attorney General Letitia James in a lawsuit against Trump, effectively deciding that no trial was needed to determine that he had fraudulently secured favorable terms on loans and insurance deals. The New York Attorney General has argued that Mr. Trump inflated the value of his properties by as much as $2.2 billion and is seeking a penalty of about $250 million in a trial scheduled to begin as early as Monday. Still trying to unpack and wrap my head around the legal consequences here and what this means, but it means really bad things and very embarrassing things for the Trump Organization. And I think that is good news because justice matters, as our friend Glenn Kirshner would say. And also in Trump world, I am really getting a lot out of these Cassidy Hutchinson interviews. She sat down with Rachel Maddow and Jake Tapper, and then last night, best of all, Lawrence O'Donnell did a great interview with her. And I don't have time to grab those clips and get this show out, but I highly recommend that you watch those interviews. It'll be very interesting to see if and what she does and says in testimony against Trump at these upcoming trials, specifically the January 6th trial led by the federal government, Special Prosecutor Jack Smith. But let's head over to Biden world, shall we? Because yesterday, President Biden, the current president, well, he made history when he became the first sitting president to join a picket line. President Biden yesterday met with striking workers in Wayne, Michigan, and I'll share a little audio of that, but I think this 2-minute news update from CBS News is helpful about the strike against Detroit's big three automakers, which is now expanded after the companies failed to make progress in negotiations. Here's CBS News' Sean McCleaver.
One day longer, one day stronger! Woo! Across 20 states, coast to coast, approximately 5,600 more auto workers walked off the job at 38 parts distribution centers belonging to General Motors and Chrysler parent Stellantis as their union expanded its week-long strike against the Big Three.
Our stand-up strike strategy is designed to do one thing: win record contracts after years of record profits.
Shutting down parts distribution means consumers may soon feel the impact of the strike as car dealers run out of parts for repairs.
They're regarded as cash cows for the companies.
Wayne State University business professor Merrick Masters.
It affects customer relations, and the union wants to have an impact on the companies where it will be most keenly felt, and they know that they are dependent on their customer base.
Already on strike are nearly 13,000 union employees at 3 Midwest plants.
Fair pay! Fair benefits!
General Motors called the expanded walkout unnecessary. The union did not expand its strike against Ford today, saying they'd made real progress finding agreement on things like cost of living and job protections, but the two sides remain far apart when it comes to pay. Nora?
Chris Van Cleve, thank you.
Chris Van Cleve, thank you. Nora, thank you. So there's a little bit of an update. I took out some of that to shorten it. It was about leaked messages for strategy, which I thought was unnecessary. Anyway, President Biden was on the picket line yesterday in support of striking auto workers. Here's the man with the most gravitas. It's Lester Holt over at NBC Nightly News.
Biden today inserted himself in a labor dispute in a way no other modern president has, joining striking auto workers on the picket line outside a GM plant near Detroit, through a bullhorn telling workers they deserve the significant raise they need, and standing shoulder to shoulder with picketers as UAW leader Shawn Fain railed against corporate greed. The president making the trip 12 days into the strike against the big three automakers. His visit marking a major shift from keeping a distance from negotiations to proudly siding with union members, all against the background of the 2024 election, underscored by former President Trump's plans to visit tomorrow. Gabe Gutierrez is in Michigan with late details.
In a historic visit, a U.S. president on the picket line, throwing his full-throated support behind the striking United Auto Workers.
Gave up a lot, and the companies were in trouble. But now they're doing incredibly well. And guess what? You should be doing incredibly well, too.
President Biden at a General Motors plant outside Detroit, wearing a UAW hat and standing shoulder to shoulder with Union President Shawn Fain.
It's about the auto workers who are part of the fabric of the working class of this country.
The union has a number of demands, including 40% pay hikes. Today, the president said he supports bargaining for that, each automaker offering roughly 20% raises. The White House has not been directly involved in the negotiations.
All right, NBC News reporting, CBS News reporting, and now I just want to bring you the United Auto Workers president, Shawn Fain himself, because today, former disgraced president Donald Trump is apparently going to show up. I don't know what he's going to do, but he threw cold water on the idea that former President Donald Trump is an ally to labor. Listen to this.
As you know, former President Trump will travel to Michigan tomorrow to give a speech to auto workers in Detroit. Many of your members are supporters of his. He wrote this on his social media just ahead of President Biden's visit there today. This is from Trump. Joe Biden's draconian and indefensible electric vehicle mandate will annihilate the U.S. auto industry and cost countless thousands of auto workers their jobs. Is the former president right? Does the push for electric vehicles here in the United States hurt your union?
It doesn't if it's a just transition, and that's what we're fighting for right now. It doesn't if the companies do the right thing and put this work under, our agreements or to our standards. And again, it's the companies driving this race to the bottom, and they're using our tax dollars to finance it. And, I find a pathetic irony that the former president is going to hold a rally for union members at a non-union business. And, all you have to do is look at his track record. His track record speaks for itself. In 2008, during the Great Recession, he blamed UAW members. He blamed our contracts for everything that was wrong with these companies. That's a complete lie. In 2015, when he was running for president, he talked about doing a rotation, taking all these good-paying jobs in the Midwest and moving them somewhere in the South where people work for less money, and then to make people beg for their jobs back at lower wages. And the ultimate show of how much he cares about our workers was in 2019 when he was the president of the United States. Where was he then? Our workers at GM were on strike for 60 days, for 2 months. They were out there on the picket lines. I didn't see him hold a rally. I didn't see him stand up at the picket line, and I sure as hell didn't hear him comment about it.
So here's the question.
He was missing in action.
Here's the question to President. What about the meeting with Trump? Would you meet with him when he's in Detroit tomorrow?
I see no point in meeting with him because I don't think the man has any bit of care about what our workers stand for, what the working class stands for. He serves a billionaire class, and that's what's wrong with this country.
Well, that effectively sounds as an endorsement for Biden. Am I wrong?
It's not an endorsement for anyone. It's just a flat out how I view the former president.
Oh, man, that was so good. I'm so glad that I heard that and shared it with you. Let me know what you're hearing and what you think I should be sharing with a wider audience here on Stand Up. As always, email me, standupwithpete@gmail.com. All right, one more piece of audio that I heard. It's Manu Raju, CNN congressional reporter, who really does do a great job, great work, I think. He's everywhere, and he's well respected on Capitol Hill. And yesterday he confronted the House Speaker Kevin McCarthy regarding the double standard that apparently he's got for Senator Menendez, who's been indicted, and George Santos, who's also been indicted. Now, see, he just called for Menendez resignation, so he should resign, but he hasn't called for George Santos to resign. And so Manu Raju hung him up on that, and the audio's not great. I think you can hear it. It's real quick, but here it is.
Yes. You called on Bob Menendez to resign. You did. Did you ask me? You did over the weekend. You said he should resign. Do you think that George Santos, who's been indicted on federal criminal charges, should also resign?
No. I think George could have his day in court, and I think Menendez could have his
Mr. Speaker, why do you think he's resigned then?
It could be his choice what he wants to do.
Oh, now it can be his choice. Whew, amazing. Manu Raju stringing him up there. And just more proof that Speaker McCarthy not ready for prime time with that inconsistency. He's demanding for a Democrat to resign, but not the Republican. And then he's walking it back. You know what? It could be up to them. OK, just leave me alone, Manu. Just stop it. Stop asking me these questions that are so easy for me to get wrong. And by the way, Senator Menendez is still holding strong. I can't believe that he hasn't stepped down yet, or maybe I can, given his history and the ego and arrogance that may come with being a United States senator. But yesterday, Bernie Sanders demanded that he resign. John Fetterman added his name to the list as saying that he should resign. I don't have it all for you, but it's a day, 5 or 6 since news broke that he was indicted on Friday of last week. We'll be closely following that, but every day he's still there. He's doing damage to Democrats in New Jersey and around the country by being a cartoonishly corrupt politician. But speaking of cartoonishly corrupt, I think it's time we get to another branch of the government, the Supreme Court. That's all the news I've got for you. And now it's time to get to my conversation with Professor Eric Segall. And remember, I cannot do this show without your support. Your paid subscription is what keeps it running. You can always upgrade your subscription. Yesterday, I saw somebody downgraded his subscription from $10 to $5 and threw me into a tailspin. So, yeah, you can always upgrade. And if you got to downgrade, always let me know why. What's missing? If you can't afford it, whatever it matters, I appreciate you supporting independent media, however you are supporting me and the show. Many ways to invest in it and the work that we're doing here together. So sign up now, patreon.com/Pete Dominic. All right, well, it's time to get to Eric Segall. He is a professor at Georgia State University, a very prestigious, respected scholar of constitutional law. He's written 2 books on the subject, Supreme Myths and Originalism as Faith. You can hear his podcast, Supreme Myths. Read him at Dorf on Law, where he's often contributing to a very brilliant legal blog. And most recently, his post on what we are talking about today, Top 10 Ways to Improve the Supreme Court of the United States. Ladies and gentlemen, the legal eagle, Eric Segall.
3, 2, 1... Segall! Hello. Hi.
Hi. How are you?
I'm good. I was very interested in your latest Dorf on Law piece about the upcoming term for the Supreme Court, as well as, most importantly, top 10 ways to improve the Supreme Court. But let's start with the latest with Clarence Thomas. It seems like if it's Wednesday, a new story comes out. Every week a new story comes out about Clarence Thomas and his all kinds of completely unethical corruption. What do you make of it?
Corruption may be strong, may not be strong. It might be strong, but certainly behavior that no Supreme Court justice should engage. ProPublica keeps coming out with these reports, but they're all cumulative, Pete, in one sense. Yes, billionaires have been paying for Clarence Thomas's travels, his wife's home, his mother's home, They've been paying for his kid's school. He is definitely living a billionaire lifestyle. And here's the thing about that. No lower court judge could get away with it. If this information came out about I don't know the laws of all 50 states, but I think I'm on pretty strong ground when I say if any state court judge or any lower federal court judge had this amount of largesse given to them by this number of billionaires, especially billionaires who clearly have strong interests before the court, and more importantly, billionaire is now billionaire. It used to be the Koch brothers, now it's Koch. But the Koch brothers, when they both were alive, and now the Koch that's alive, Pete, they fund so much of the Leonard Leo stuff, the FedSoc stuff. They're the ones, the Koch brothers gave George Mason Law School a whole ton of money to rename it Scalia Law School, something I think they should never have done. And so we have a Supreme Court justice feeding at the trough of these two brothers, now one brother, for decades, Pete. So it's interesting. This is a story that so far I don't think anyone has said this so far. I haven't seen it yet. I don't hold me to the exact years, either 2005 and 2006 or 2006 and 2007. Around that time, both Scalia and Thomas went to Koch brother weekends that were not, come to us and give us a talk about what it's like to be a Supreme Court justice, or come to us and talk about the federal judiciary, or come to us and talk about this or that. They didn't give any talks. They were just there hobnobbing and hand grabbing.
That was come on, shoot guns and smoke cigars.
Right. And then it was reported a few years later. And my understanding was they stopped. And I think they did. And then Scalia dies. And then I think Thomas starts doing it again. But here's the one thing if there was one thing I want your audience to understand about Justice Thomas and the world, it is this. He reported Ginny's income from sources for years. Then she went to work for Heritage, which is right now a neo-fascist organization. It wasn't always that way, but it is now. It is a racist, sexist, horrific place. One of my closest friends works there now, ex-friends works there now, and it breaks my heart every day.
Wow.
Yeah, they're the ones behind a fundraising letter that talked about all the evils of critical legal studies. And everything they said was a lie, and it was all racist, and it was terrible, and they used it to raise money. So
the Heritage Foundation has been very controversial right-wing organization, think tank, if you will, for a long time, not just because of this, but go ahead.
They also, by the way, their two favorite people are Justices Thomas and Judge Pryor of the 11th Circuit. You and I have talked a lot about Judge Pryor. He's a feeder judge to Thomas, and he's the one who hired the woman who said, "I hate all black people."
He hired a woman who said, "I hate all black people."
Yeah, well, Pryor did that because after she was fired from her job at Charlie Kirk's organization, now think about that for a second. She was too racist for Charlie Kirk's organization. I mean, that's almost inconceivable. That's like slaves. I don't know how you're too racist for Charlie Kirk, but she was too racist for. Get this, Pete. This is a great punchline. She was too racist for Charlie Kirk, and within a couple of days, she was living with Clarence and Ginny Thomas in their home. Living in their home, in their house.
Wow, you would think she would be opposed to the miscegenation.
and then, of course, they get her to apply to George Mason / Antonin Scalia Law School. She gets in. Then they get her a job for Judge Pryor of the 11th Circuit. I mean, it's just the whole thing is insane. So the thing about Thomas is he knew what the law was because he filed these disclosures for like 10 years. Then he stopped. He said publicly it was a mistake. I forget if he said a mistake or something like that, but he said it was a mistake. I'm refiling now. And he did, and that's fine. We all make mistakes. Everybody makes mistakes. And then he did it again. He stopped reporting it again years later. So he reported, he didn't, he got caught, he reported, and then he stopped again, and then get caught again. So there's one of two things going on. I dare anyone to find a logical possibility other than these three things. He's either stupid, corrupt, or stupid.
Well, I said he's corrupt, and you said that might be too strong of a word. I don't know how you would define corrupt.
I was teasing you. Dahlia Lithwick, of course, has with Mark Joseph Stern, had a great piece yesterday in Slate. Everybody should read it.
Oh, I missed it.
Yeah. Well, what it basically said was, okay, when we think of direct corruption, we think of quid pro quo. I'll give you, Mr. Justice or Mr. Congressman or whatever, $25,000, and you vote a certain way from me.
You would think, what's his name, Menendez,
right? So as far as I know, no one's accusing Thomas of that kind of bribery or quid pro quo. As far as I know, no one's accused him of that, and they probably shouldn't because we have no proof of that. Dahlia and Mark, though, made the point. What we have here is a concerted effort by billionaires to ingratiate themselves with Justice Thomas. And on the Chevron issue, Pete, the Chevron issue, where for a long time now, the rule was when an agency interprets the law, as long as the law is ambiguous in some way, the court would defer a lot to the agency consideration of it. And Justice Scalia was very much in favor of that doctrine. Now, as he was getting closer to death, he backed away a little bit. But Justice Thomas once upheld that doctrine, and now he wants to overrule it. And the only thing that's changed in the interim are these billionaires flying him on his plane. So Dahlia and Mark's point was, that is the appearance of impropriety right there. And that's the standard. It's not, is there a bribe? The standard is the appearance of impropriety. And gosh, it's more than an appearance. It is improper, period. Not even the appearance of. So I don't know what's going to happen. I mean, all this stuff will probably blow over, Pete, but it's sad because, I don't know anything about that. I have said from the minute Justice Thomas uttered the words high-tech lynching when Anita Hill accused him of sexual harassment. And if Justice Thomas had not been confirmed because of Anita Hill's allegations or any other allegations, he would have gone back to the U.S. Court of Appeals for the D.C. Circuit, which people consider to be the second highest court in the land, and he had life tenure and all that stuff. So what was at stake was either being a judge on the D.C. Court of Appeals or being a judge on the Supreme Court. You want to compare that to lynching for a minute?
Yeah. Well, somebody tweeted yesterday about, it's like always an appropriate tweet about if we'd only believed Anita Hill, how much different the world would be.
Yes. Well, probably. Yes. I mean, Bush may have had time to nominate somebody else, but maybe not. I mean, it was getting late. I mean, so who knows? Anyway, the Thomas thing, what will be interesting to see a little bit is if he's as vocal at oral arguments this year as he's been the last couple of years. Ever since they went to, live streaming the sound of it, he has been asking questions. I feel like if he comes out of the gate strong, that's just, I don't know. I mean, I wrote in the LA Times in 2012, that Elena Kagan should recuse in the Affordable Care Act case. And the people calling on Justice Thomas to recuse didn't really have it right. We didn't have all the facts. But what I also said in 2012 was, even if Thomas should recuse, why in the world would we ever expect him to do the right thing? Because he never has. He never has. He's done the wrong thing every time. One quick.
That was 11 years ago that you wrote that.
I know. It's unbelievable. At his confirmation hearing, he said he never debated Roe versus Wade ever, even though he went to law school in 1973. Graduated in 73, the year Roe was decided, and even though he worked in government and all that stuff, and he's part of the Federalist Society and all of that. And then we found evidence that, in fact, he did tell leading Republicans that he thought Roe was bad. So that was perjury. He committed perjury that day. And since that moment of time, that and the high-tech lynching, he's just a man of very little character. It's really sad.
Well, who hasn't committed perjury in their confirmation hearings?
Well, that's fair, too, actually. That's a fair point.
So before we get to the upcoming term, we've been talking about Clarence Thomas and his corruption and the latest developments from ProPublica on him. And we want to talk about the 10 ways to improve the court and the upcoming term. Anything else we needed to hit on before? Something about the Fifth Circuit. Why are you tweeting about the Fifth Circuit?
Jesus Christ. So I made an announcement today, and it was drastic for me. I didn't make it in a drastic way, but it was drastic. For the first time in my life today, I called a different court not a court.
Oh.
And Until today, my position was the only court in America that's really not a court is the Supreme Court of the United States.
I didn't realize that. Okay.
But the Fifth Circuit has now earned that award as well.
Oh, what?
And here's a very specific reason why. The Fifth Circuit has been terrible for a long, long time. That isn't it. Terrible courts are still courts. There's terrible courts. The reason why the Fifth Circuit is not a court anymore is the same reason the Supreme Court is not a court anymore. They don't care about precedent at all. They don't care. They're starting anew every case. Anything that gets them to win the culture wars, they do. And even binding precedent from the Supreme Court. People will remember they basically overruled Roe before Roe was overruled, and the Supreme Court said that was fine. Even though the court tells lower courts all the time, you can't overrule us until we explicitly do it. But the Fifth Circuit's been doing it now for years. They don't even care what the Supreme Court says. They just do what they want to do, and that's been consistent. Judge Ho. There's a lot of really terrible judges there. And it breaks my heart, Pete, because one of the new hotshot judges there, who used to be in the news all the time, was a guy named Judge Don Willett, who was the first judge on Twitter, who really had like 30,000 followers and really engaged on Twitter. And he went off of Twitter. He was on the Texas Supreme Court. Then he got promoted to the Fifth Circuit, and he stopped using Twitter. He and I are friends, and he's not a bad guy, but he's going along with this lunacy of the Fifth Circuit. So the Fifth Circuit issued a decision that the court's going to review this term that could effectively end the administrative state. And then I'm not worried about it. I don't want to talk about it because the court's not going to uphold it. But it's so drastic. It's so insane. And Mark Joseph Stern wrote about that today, I think. So you can find that today on his timeline. If you're just today is Monday, whenever you listen to it.
Yeah, here it is.
I just want to say that there's a bunch. Part of the problem is they're crazy people, and part of the problem is they want to be on the Supreme Court of the United States. So Judge Ho, who was one of the intellectual leaders of that circuit, is young, fairly young, and he wants to be on the Supreme Court so badly. So everything he does is to please the Republican Party. And that cuts across everything.
He's a Trump appointee.
He's just awful. He couldn't be worse. He's as bad as Thomas. I mean, he's just awful. He's a Thomas clerk, by the way.
Of course. Well, that makes sense then.
So is John Eastman, of course. So is Laura Ingraham, of course. Go on and on.
Well, let's talk about what is coming up. Next Monday, the Supreme Court starts its new term. Yep. As you write here, amidst more than the usual share of controversy surrounding the justices, you say the public seems to strongly disapprove of the court's landmark abortion decision that returned the issue completely to the political process. Moreover, just about every week, there's new reporting about Justice Thomas's wildly inappropriate billionaire-paid lavish lifestyle, Justice Alito, publicly obnoxious and wrong, or one of the other justices trying unsuccessfully to defend the institution against charges of partisanship. The justices' approvals rating is at an all-time low, which sets the table for this next term.
Yes. Well, there are some big cases, too. The court is way behind in picking cases compared to where it usually is. But there are 4 big ones. Should we do them?
Yeah, let's go.
So I think everybody's heard about the Alabama case, where the Supreme Court basically said, look, Alabama is, I'm going to paraphrase a little bit, but Alabama is 27% black, and they have 1 congressional seat out of a ton. So under the Voting Rights Act, so one part of the Voting Rights Act, the Supreme Court struck down. That's the part that said Texas and Georgia and South Carolina had to pre-clear their voting requirements, election rules, before they could impose them. That's been struck down. There's another part of the Voting Rights Act, Section 2, that allows anybody, you, me, the government, to sue a state if they engage in intentional racial discrimination in voting. Alabama clearly engaged in racial discrimination in voting. The Supreme Court said that in a surprising opinion last June. And they said, go back and redraw the maps, because what they want to have happen, Pete, is given the requirements of the Voting Rights Act, instead of having 1 majority-minority district, that means a district where there are more blacks than whites. And unlike a lot of states in Alabama, it's a binary. It's mostly white and black. I mean, there are some Asians and stuff, but unlike California, it's mostly white-black. And so anyway, so Alabama went back and they ignored the Supreme Court's opinion. And
they did?
Yes. And instead of creating 2 majority-minority black districts, they only created 1. And that's going to go up to the Supreme Court. And I think they're going to say to Alabama, what the fuck are you doing? Follow our decision. Because they didn't. Alabama just did not. Now, the one footnote here, and the reason Alabama did this, and Pete, if this happens, it's cataclysmic. When the court upheld this, when the court said the first time, what Alabama did was wrong, it violates the Voting Rights Act, there should be 2 majority-minority districts. Kavanaugh agreed with all of that. But I agree, that's fair. And then he dropped this bombshell. But I'm open to the argument that Section 2 is unconstitutional. And that's what Alabama's counting on.
Oh.
That I know. And if that happens, I don't think it will. But if that happens, that would mean the entire Voting Rights Act is basically gone for almost all intents and purposes.
I'm open to that. It's unconstitutional. The Voting Rights Act, Section 2, which was, of course, passed by Lyndon Johnson because of the Civil Rights Movement, which was reaffirmed by the United States Senate like 98-0 over and over. And now all of a sudden, after years and years and years of it being reaffirmed for good reasons, and now all of a sudden Kavanaugh's like, it might be that thing that basically made America a lot more fair and gave and protected voting rights. I don't know. Might not be.
Well, what he would say, to be fair,
okay.
What he would say if he heard you say that is, we always knew the Voting Rights Act was strong medicine, and that's fair. That's a fair observation. We always knew it was strong medicine. The reason it was strong medicine, by the way, is they were treating like the worst disease ever.
Well, yeah.
American racism and voting.
Yeah.
But he would say, it can't. What he did say is, I'm not convinced this should go on forever, and with the passage of time, we don't need it anymore. But that is really stupid, and it's the same rationale Roberts used in Shelby County, where Ginsburg. So when they struck down Section 5 in Shelby County, Ginsburg said, and it's one of the best. I'm not sure it's an analogy, a comparison, a metaphor, but it really hits home. Ginsburg said in dissent, maybe her strongest dissent ever was Shelby County, maybe. She said, it's like throwing away your raincoat in the middle of a rainstorm because it's been working. The Voting Rights Act was working to cure one of the worst evils in American history. From 1890-ish, 1885-ish, until 1964-ish, the South and other places did not let blacks vote. They used violence, character tests, literacy tests, and that's generation after generation and generation of racial discrimination in voting. And the Voting Rights Act was strong medicine to cure that, and it has not been cured, as voter ID laws and Sunday closing laws and everything the GOP is doing today shows. So this would be a real disaster. If they strike down Section 2, that's an American disaster. I don't think they're going to, but we'll see.
The exact quote from Justice Ginsburg, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet.
Pete, that was impressive. Did everybody get that? That's my man right there.
Well,
can I just name parts of Supreme Court decisions and you'll go read them? Will that work?
Quick. I'm quick on the Google. So you've trained me well, Jedi.
Yeah, okay, so that's the voting rights case. Then we have the most important case of the term, and so far, in my opinion, which is U.S. versus Rahimi, which is a case I can barely talk about without throwing up onto the screen. But luckily, this is audio only, so nobody will see that. Once again, we're back at the Fifth Circuit, our lovely Fifth Circuit, who decided, and I know your audience knows this already, who decided that being under a domestic relations protective order, so you can't go within a certain number of feet of your girlfriend, after being arrested for multiple gun offenses multiple times, is not enough to strip you of your gun rights. And what they said, they issued a revised opinion because this is actually pretty rare. The Fifth Circuit issued an opinion upholding that. Then they issued a revised opinion because the first opinion relied strongly on the idea that the founding fathers didn't think domestic violence was a problem. So they didn't have laws against being armed if you're a domestic violence person. So we're not going to, it's unbelievable. But that, by the way, is consistent with the court's decision in Brune. That is what the court is telling lower courts to do. It's insane. Anyway, they issued a renewed opinion that relies less on that idea. But that's generally the idea, that there weren't laws like this in 1791, so there shouldn't be laws like this now. I want your audience to forget law for a second. Forget law. Forget con law, forget Supreme Court, just common sense here. Congress decides, pursuant to numerous of its powers, to say that if you are the subject of a domestic relations protective order, meaning a judge has reason to believe you are going to hurt someone in your own house, you're not allowed to have a gun.
So there's a restraining order against me. I'm not allowed to have a gun. That's what this law is. And you're saying if Congress decides that,
either Congress or the states. It wouldn't matter.
The state legislature. The legislature decides.
I mean, in this case, it was Congress, but it could be the states. Doesn't matter. My point is, how is that not totally reasonable, consistent, what we need? Do you know how many murders of women are done through guns and domestic violence? Like a lot. Gun homicides and domestic violence situations are really, really high. And then think of all the times a guy has a gun and he's waving it around, doesn't shoot his wife, but is threatening her if she does what he says. It's unbelievable that in 2023, 5 of 9 Supreme Court judges, or 6 of 9 in this case, could think that's okay. That it's okay to be armed when a judge has already ruled you're too dangerous to go within X number of feet of your ex-girlfriend or your wife or whatever. It's just insane. I actually think the court is going to overturn the Fifth Circuit, and I think the court is going to adjust what it decided. The Bruin case is impossible, Pete. The Bruin case said the only laws we can uphold relating to guns are laws that existed in 1791 or laws like those that were passed in 1791. And we don't live in 1791. We live 2 centuries later, or 2.5 centuries later, and the dangers we have today aren't the same. Like you can't it's so stupid I can't even talk about it.
All right, well, okay, so that's the Rahimi case. This is the Zachary Rahimi is the guy's name who is trying to get a gun under a restraining order, apparently. So what's the third case?
The third case is a really interesting one, and one that I actually wrote about on Dorf on Law a couple of years ago, the issue. It's a pair of cases, different facts, but here's the issue, and it's not easy. A school board member or a mayor or a local state official of some kind has a government Facebook page. Someone comes in and heavily criticizes, that kind of thing. Can they block that person from a government Facebook page? And this issue is complex. Now, I believe one of those cases also involves a personal Facebook page. I think that's different. But let's just take the issue of, does the mayor of Atlanta have to allow everybody on her official mayor of Atlanta Facebook page? And I don't know what the answer to the question is. I don't know what the right answer is. My intuition is they should be able to block abusive people, but maybe not people who just politically disagree with them. But I'm not sure. But here's my takeaway for your audience. It's a complicated issue. No matter what the right answer is, no matter how we find it, you know where we're not going to find it? 1791.
Right.
So the idea that 1868 when the First Amendment was made.
They didn't have blocking people on Facebook.
Not only that, they didn't have anything comparable. There's nothing you can even come close to comparing it to. And think about this for 1 second. On the one hand, a mayor having a Facebook page, or even a school board member, or whatever, is a great thing. It's a democracy enhancing thing. More people can communicate. You can have all the stuff that Facebook does. That's a good thing. On the other hand, no one should be allowed to abuse somebody else.
Right. It's a tough one. It's a tough one. And I'm a Facebook warrior. So I have a lot of thoughts on this. You're running for office and every day or you're in office, you're the town supervisor, and every day some lunatic's calling you a pedophile or a groomer.
Right. Well, that's different. Speech that's not that would be slander if it's not true.
You could insinuate horrible things every day that had nothing to do with the truth.
Yeah. On the other hand, that's the argument. That's a great policy argument, Pete. You had me hello. But here's the response, and it's not a frivolous one. That line eventually will be drawn in a way that it's not just offensive, kind of really offensive things or untrue things, but just criticism.
Sure.
And then we'll have more silos.
I certainly could see that happening in my town, much less a lot of other places. Right. Yeah,
so I'll be honest. This is one I don't know the right answer to. I think it's hard. I think it's complicated. I have only one strong opinion. Whatever we do with this, it should be according to today's needs, today's values, today's world, not the world of 1791. But we're lucky about it. But Pete, actually, we're lucky on this because of the hundreds of free speech cases the court has decided. Only one has an originalist undertone to it. And that's the Pentagon Papers case back in 1971 or two, when the Post and the Times wanted to disclose information. The government said no. The reason that's obviously unconstitutional is that's a prior restraint. And prior, meaning The government was stopping speech before it was happening. And that's what the founding fathers were afraid of. They weren't afraid of punishing speech after the fact. They were afraid of the government coming in and not letting speech out. So if you're an originalist, everything the Supreme Court has done in the First Amendment arena, which is a lot, should be wrong. Of course, there are no real originalists, and nobody's saying that.
What about this? Yesterday, headline, as Trump was going on some kind of rants on his third-rate social media platform, and he pledged to investigate certain television news networks, MSNBC, for example, for threatening treason. That would be
lower on in that whatever you call it, tweet or whatever it was. He says they should put to death.
Who should be put to death?
Read the whole thing.
I know he called for Mark Milley to be put to death. I didn't realize.
I think he made a threat. Oh, maybe that was right. I think he made threats against MSNBC also. Pretty sure. Maybe not death, but he made threats. Pete, listen. You and I have talked about this so many times. People show you who they are. You know, the first time you had me on your show, the second time, not the first time, but the second time first time I was a caller, but the second time when I was a guest on your show, I told your audience basically who I was in that very first show.
Sure did.
And I've evolved a little bit since, but I mean, that's who I am.
I think you've devolved.
Maybe that's possible. When you get to be 65, Pete, everything falls apart. When we're at the point where the front runner for the Republican Party is telling us he's going to be a dictator, we should believe him. Now, he may not be, if he wins the election, he may not be successful at being a dictator, but he's going to try. They're not hiding it. And the way they're going to do it, Pete, is our civil service.
Yeah, deconstruct the administrative state, the 2025 plan, and Steve Bannon spearheading this. And I don't think we need to look at what they said they're going to do. We can look at what they did and what progress they made. And certainly a lot of the ability to do that is as a result of the judges that he was appointed at lower and the Supreme Court, which is why we talk to you so much, because it has a direct effect on our lives when he gains more leverage to actually legally destroy the state, because his courts will look the other way and say it's not.
Well said. And speaking of that, so the fourth, and that's the bridge to the fourth case. Another Fifth Circuit case, of course, because they're destroying the planet. The consumer, the CFPB, the Consumer Financial Protection Bureau, I believe created in the wake of the 2008 economic crisis.
Yeah, I covered that a lot.
The Fifth Circuit held that the entire agency is unconstitutional because of the way it's funded. The way it's funded is also the way a lot of other agencies are funded. This is an absolute attack on the administrative state. If the Supreme Court affirms this decision on the grounds that the Fifth Circuit decided it, Mark Stern had a piece on this today, or the day before, I think today. The entire administrative state is in jeopardy, could be gone. I'm talking about OSHA. I'm talking about everything. So this is another example.
Ian Millhiser at Vox, the headline is, a new Supreme Court case could trigger a second Great Depression. America's Trumpiest court handed down a shockingly dangerous decision. The Supreme Court is likely, but not certain, to fix it. It's the Consumer Financial Protection Bureau versus Community Financial Services Association. The argument.
Here's the problem. I'm going to try to explain this at a decent level of generality. The phrase, this is a big topic, Pete. The phrase separation of powers, which we all know and we all love, and I'm totally in favor of the separation of powers, is not in the Constitution. It's never there. Those words are not in there. What we know is the Founding Fathers wanted a system of checks and balances and separation of powers, and also accommodation. The president and the Congress work together in making laws. The Senate has to approve presidential appointments. You know, the Congress gets to declare war, but the president's the commander in chief. It's all about splitting the atom to avoid. This is my line, Pete. Splitting the atom to avoid tyranny, but not too much, so we can still have an efficient government. Well, that's in some cases that's hard. Like that's a nifty balance there, right? The best example of the pressure of this kind of is during the Korean War. There was going to be a steel strike nationwide, and Truman's lawyers went to the Supreme Court and said, we have to seize the steel mills, because if we don't, our men and women in Korea are going to die. Now, the court didn't believe the lawyers, so the court said Truman could not seize the steel mills. But here's what the court was balancing. We want the president to keep our troops safe, efficiency. We all do. Everybody wants the president to keep our troops safe. That's efficiency. But we don't want him to keep him safe in a way that's tyrannical. So there's always this tension in separation of powers cases between the need for an efficient government and the fear of a tyrannical government. This case raises none of that. That's why it's so stupid. This case raises none of that.
I'm just I'm looking at Ian's piece at Vox, and you touched on this, but just to be clear, if taken seriously, the argument here being made would invalidate most federal spending. It would invalidate most federal spending. I wish I could speak. It would make impossible things like Social Security and Medicare to even exist under this weird interpretation of the Constitution. Moreover, he writes, many key federal programs simply could not exist.
Yes. And that's Trump's endgame. And that's Trump judges' endgame. I don't think that
would be their endgame. They would be there to kill those programs.
Yes. You okay?
I sneezed.
Okay. You turned away. I couldn't tell what you were doing.
I turned away and hit the cough button and sneezed, and you thought I had passed. It perished.
I thought maybe you were having a heart attack. I was getting worried. I've had too many losses in the last 2 years. You can't.
I'm hanging out. I'm hanging around, buddy. I'm not going anywhere.
Good.
But
Please.
the point, this is a big deal case, and it does not look like the Supreme Court will decide this in favor of the conservative argument.
But you know what they'll probably do? They'll probably reverse. Knowing if Justice Roberts gets his way, which he doesn't anymore, there are 5 people to his right. But you want to make the chief happy. If you're a Supreme Court justice, you want to make the chief happy because he gets to decide who writes which opinions if he's in the majority. Anyway, Roberts will write some kind of opinion, maybe, reversing the Fifth Circuit, but still finding the funding mechanism unconstitutional, but in a way that doesn't jeopardize other programs directly. And then he'll let more lower courts strike down those programs, as opposed to doing it all at once. Roberts is very smart at this. He'll throw out a rule which he knows lower courts will use to do what he wants, and then he doesn't have to do it. It's a very, very smart thing. Actually.
Well, do you know what the Consumer Financial Protection Bureau was created and when and for why?
I believe 2007 or 8. I don't know, to help with the crisis.
Obama was elected, and they had control of Congress for those first 2 years. And one of the things they did, led by Elizabeth Warren in the Senate, Barney Frank in the House, was they created these regulations that would prevent the financial institutions from doing what they did to create the crisis, and a lot more. And then it was demagogued and demonized and stripped naked of a lot of the restrictions, but it was still doing some good work. But it's been attacked, and it's just the craziest thing because it was a global financial meltdown as a result of America's deregulated financial rules. This agency comes in to fix that, and Republicans and conservatives hate it. For why? For what? So the banks can fuck all those conservatives again? They all got screwed too.
Why do conservatives hate it? Well, first of all, they hate Elizabeth Warren.
They hate government. They hate regulations. I understand that, but
hold on. No, that's not
you got to go a little deeper with your argument, folks.
No, hold on. They don't hate government. They hate non-military government, and that's yes and no. Now they hate the military too because the military is woke. I mean, now it's like it doesn't even. Nothing means anything. Those old arguments, it's like whatever Trump, I've been ranting and raving locally on my local Facebook page about how you cannot support veterans and Donald Trump because he has so demonized veterans and the military, but they are now making arguments that the military's woke. And that's why we're not going to win any more wars, and people buy them. Pete, I think it's a reasonable observation, but you know as much about this as I do, so correct me. I think the Trump powers that be, whoever the Trump people are, but even the Ted Cruz's and the Rand Pauls, the Harleys, I think they're all in bed with the Russians. I'm sorry, I do. What other explanation is there for?
I don't buy that at all. In bed with meaning what?
Why are they not wanting aid to go to Ukraine? What's that about?
It's not being in bed with. Because I can actually explain that. It's very easy. They are completely, totally unprincipled and they're nihilists. They don't care about.
So is Ed Meese, but he wasn't in bed with the Russians.
No, there's no evidence that I've heard that they're in any way compromised or being paid off. The more obvious truth is that they follow right-wing media. They do whatever arguments they must to remain relevant to get reelected. And then they govern against the interests of their own people. And they don't seem to care because they're so distracted by these ridiculous arguments. And one of the ridiculous arguments is that we should not fund with just 5% of our defense budget the war in Ukraine to destroy Russia. And yet those same people overwhelmingly supported the invasion of Iraq. So it doesn't make a lot of sense.
That's not, see, what I'm saying to you is there's a weird thing going on right now, whatever it is. I mean, okay, there is one fact that we have to wrestle with. I mean, or at least acknowledge, if not wrestle with. On July 4th, either 17, 16, or 18, I forget which, all of these senators, 8 of these senators went to Russia together as a group on July 4th, and no one's ever explained why they did it.
Well, yeah. I mean, I think I don't see anything foul play. If anything, I will give you, unless there's any evidence to make that argument.
How about Trump having Miss Universe in Moscow in 2013?
Listen, Trump, there's plenty of questions about, and his kids. But Ted Cruz and some of those other senators, I firmly believe that a lot of Republicans like Russia, because Russia will interfere in our elections to help them get elected, but they're not having any communications or any paid off. They just know that Russia's on the side of this minority party with their minority thoughts. They can't get elected legally, so they have to take the interference, and it works. And I think Trump obviously invited.
I bow to your superior political.
I don't know. Let's get back to.
Can we do a speed round of my top 10 things?
I can do a speed round. I actually think. Well, I mean, I don't know how you want to do it because I actually could just list them off here almost.
How about I do it real quickly?
Go ahead.
Okay. So first and foremost, of course, we need term limits because
Again, these are the top 10 ways to improve the Supreme Court of the United States with constitutional law scholar Eric Segall, the legal eagle.
And I'm only doing 9 because the 10th is boring and kind of mine. So here are 9 ways. Okay. So term limits. Of course, no democracy in the history of time has ever said to a group of 9 people, here's unreviewable power for life. No one's ever done that. It's a terrible democracy. It's a terrible idea. We got to get rid of it. And we can do it without a constitutional amendment. We just serve 18-year terms, and then you can be a senior judge on the lower courts. You get your full salary. It's fully constitutional, in my opinion. We need term limits. That's
other countries, other courts have term limits, yes?
The only other Supreme Court of a country in the world that has life tenure is, I think, Iceland, but they don't have any. That court doesn't have any power. There is no powerful court in the world with life tenure. Ours is the only one, ever. That's 1. 2. There are only 9 judges in the entire country that have no ethics code, and that's the Supreme Court judges. We need a binding ethics code that's been talked about ad nauseum for the justices. Similarly, we need recusal rules that are binding, that are enforceable, and that make sense. So term limits, ethics, recusal rules. Everybody knows about that.
And code of ethics would have to be passed by legislation through Congress.
No. My plan would be for Congress to say to the court, you have 2 years to develop a binding, enforceable judicial ethics code yourselves. Because we don't want to do it for you. You should do it for yourselves.
Oh.
Make it enforceable. If not, you lose 70% of your budget.
Oh. Okay, so and the enforceable recusal, that's 2 and 3.
That's 1, 2, and 3. Term limits, ethics, recusal. Now, of course, cameras in the court. You and I have talked about that too many times. The public is allowed to see it. C-SPAN is willing to pay for it. That being the case, there is no excuse for not putting them on TV or live streaming on video or whatever. That's easy. That's the only one, by the way, it's going to happen. Maybe not this year or next year. That will happen within 10 years.
You do think it will? Okay.
Yeah, that one will. Papers. So the justices still really do have papers, not email files, believe it or not, most of them. And there is no rule regarding taxpayer-funded case files at the Supreme Court. So, for example, and when your audience hears this, I wish I could hear them gasp, because this should elicit a gasp. Justice O'Connor was at one time the most important judge in America. Jeffrey Toobin once said, we are all living in Justice O'Connor's America. She was the swing vote for a number of years. Then she wasn't, but she was. In any event, she was an incredibly important justice. Incredibly important. Pete, do you know when we get to see her taxpayer-funded papers? Ask me the question.
When do we get to see her taxpayer-funded papers?
50 years after the last justice she worked with is off the court. She worked with Justice Thomas, which means we're at least 50 years. We're 50 years from the retirement or death of Justice Thomas, from seeing I'll be dead, you'll be dead, many of my students will be dead. It's absolutely obscene. It's absurd.
Don't you hear everybody gasping?
I mean, how can we live in a country where official documents get sequestered for 75 years or a century? I mean, it's insane.
Number 6.
This writ of certiorari. It takes 4 votes for the court to hear a case. Everybody knows that. It takes 4 votes to grant the writ of certiorari. Except that rule's not written down anywhere. It's not formalized anywhere. They just made it up. They just do it. And in addition, and this is amazing, there is no official record keeping by any human being or any computer of who votes to hear which cases and who votes not to hear which cases. It's a completely secret process. There's no transparency. Zero. The empty set. Null and void. And you know what's the most important decision they make? Whether to hear the case. If they don't hear it, they can't make law about it. So it's an incredibly mysterious process, and it's wrong. And we should know on every case, maybe after the case is decided, maybe before the case is decided, I don't care. But we should know. It turns out from Justice Blackmun's private papers, Blackmun was generous in letting his papers become public earlier rather than later.
Huh. The justice can allow for it.
Each one has its own individual rules, which is incredibly stupid too, by the way. It's one rule for everybody, obviously. That's an obvious thing. But from Blackmun's papers, we found out, now this isn't official because they're Blackmun, not an official court recorder, But according to Blackmun's records, it appears Justice William Rehnquist, Chief Justice of the United States, literally never voted to hear a civil rights case.
So we should be...
for affirmative action.
I stepped on that, but that's an important point. We should be able to see what justices voted to take a case.
Of course.
And now we've got the shadow docket. We got to talk about the shadow docket.
So Steve Vladeck was with.
I think this is number 7, but doesn't matter. Go ahead.
Steve Vladeck, Professor Steve Vladeck, University of Texas, who I was with a couple of days ago in Long Island, talking about Supreme Court transparency and things. He wrote a book called The Shadow Docket. It's a great book. Everybody should read it. But over the last few years, the court has completely changed the free exercise clause jurisprudence through the shadow docket. It's really amazing. Shadow docket is when there's some kind of heightened need for a quick decision. Now, there are times when the court has to act in an emergency. There are, and that's fine. But what Steve's book reflects and what we know is that used to be really rare. The Roberts Court is using it as an aggressive tool, although the chief is against it. This really started to get really bad only when Barrett joined the court, and there were 5 to the right of the chief. The chief doesn't like this so much. But anyway, the shadow docket is this thing where the court changes the law without full briefing, without oral argument, and it's a terrible thing.
Crazy.
It's not something to do. Yeah.
Dahlia rails on that.
Dahlia's right.
The court ends its term every year on or about the last day of June.
So I get to now say Judge Posner's name. This is one of the things that drove Judge Posner crazy. It just drove him crazy. And I have him on tape screaming about this. And it's actually pretty funny if you hear it. Posner said, there's no reason why June 30th should be the deadline for the Supreme Court to issue decisions. It's a fake deadline. They're not school children. They don't have to have summer vacation. Now, it turns out they have summer vacation, but they don't need to have summer vacation. And we know for a fact that often the most important cases get rushed at the end because of this fake deadline. So just one example, the big Obamacare case. You and I spent, 50 hours talking about the Affordable Care Act. That case came down, and because Justice Roberts changed his mind at the last minute on that case, but the justices felt they had to release it by June 30th, Scalia's dissent reads like a majority opinion. Roberts' plurality opinion reads like a concurrent. It all got screwed up because Roberts changed his mind. So they just did a last minute kind of changing. That's ridiculous. Issue the decision when you're ready to issue the decision. I mean, it's crazy. This is the most, Pete, and not only that, but what happens is the last week of June, you and I spend 4 days instead of 1 day a week. But forget you and me, big media outlets only have so much time.
Yeah, there's no way for the media outlet, much less the public, to be able to analyze and explain to. Yes.
And I've had, since you, Pete Dominic, since you made me do my social media career completely on you.
Yeah.
Since you started that for me.
You're welcome, America.
There have been either they're happy or sad. One of those two things. I'm not sure which. I've had, it just so happens that the end of June is a time when my wife's family, my kids can go on vacation. So I'm often on vacation the last week of June, but they know I'm not really on vacation and I've had times where I've had to, like, you and I have had to talk like 3 times a day. Remember? Like, I was in Florida once and you and I talked 3 times. I think it was the year of Obergefell and the Obamacare case. And it's just nuts. Like, why do it that way?
It's artificial. There's no, I had no idea. Of all the time that we've talked, I never knew about that. The last one, though, is confirmation hearings. As Elena Kagan once wrote, you said, they are vapid and hollow charade.
She wrote that as a law professor, obviously. And that, by the way, was the first question she was asked, or second question she was asked at confirmation. And you know what she said?
I forget. I did know, though.
She said, I was just a law professor. You know, I didn't know what I was doing.
Well, what else was she supposed to say?
I'll tell you what she's supposed to say. I'm going to do it right now. Okay. I want you to set this up. Then we'll end the podcast.
Yeah.
I want you to say to me, she was the Solicitor General then? So
when you were the Solicitor General, you described these confirmation hearings as a vapid and hollow charade. Now you are the nominee at your confirmation hearings. Do you indeed still believe these are a vapid and hollow charade?
That's an excellent question, Senator. Thank you very much.
Mm-hmm.
I've been giving my answer a lot of thought. And as the former dean of Harvard Law School and a law professor, I have thought about this issue long before I came here to talk to you senators. And here's why I wrote that. I don't think that the confirmation hearings that I was talking about when I wrote that piece elicited helpful answers for the American people. And I wrote in that article that the purpose of confirmation hearings, in addition to deciding whether I'm a person who should run the Supreme Court, is to educate the public about what we do and what the court does, And I think we can greatly improve this process if maybe more follow-up questions were asked, and I'm willing to answer them. You ask me follow-up questions, I will answer them. And if you ask me how I feel about abortion or affirmative action or campaign finance reform, I'll tell you right now, I'm going to give you my answer. I'm a law professor. I have thought about these issues for a long time, but never as a judge. I will tell you what my law professor perspective is on this, and then I'll say, I'm not promising anything. I'm not committing to anything. Once I see briefs and I have parties before me, I may act differently. But of course, I have predisposed views about the major constitutional law issues of our time. I've been dealing with constitutional law for 3 decades. So I will tell you how I feel, but it's just today. And it could change. I change my mind all the time. And that's how we can move this.
Well, now, I'll say this, Justice.
I wasn't finished. Hold on. Senator, let me finish. My last sentence is, maybe I shouldn't have called it a vapid and hollow charade. That's law professors speak for getting published. But I didn't like the process. I don't like it now, and I'm not going to lie to you. If she does that, she becomes an American hero overnight, and they have to confirm. They have to confirm.
Now, Justice, that answer is fine as frog's hair split 4 ways.
Yes, Judge Kennedy, I'm doing my best.
I don't.
Senator Kennedy. The wrong senator, the bad senator.
I don't even know what accent I was really
Senator Kennedy from Louisiana.
That's
it's the closest thing to a cartoon character I've ever seen.
All right. Well, that's a great. People can read it at the Dorfon Law, where you posted all those in even more detail. Well, maybe less detail than we talked about, but that was a great conversation. A lot of great perspectives, and we'll have a lot to talk about in this term that starts next Monday. Should be really. You never know.
Yeah. Watch out for this Alabama case. If they strike down the Voting Rights Act, Section 2, that's a Change America type of case.
But they probably won't.
I don't think they will, Pete, but listen, anyone who's willing to predict what these 6 people are going to do should be very, very careful.
Do you know when they're hearing that one?
The oral argument's going to be either October or November on that, but early in term.
Yeah. All right, buddy. I appreciate you very much. Thank you very much for stopping by.
My pleasure. Take care.
All right, there he goes, Eric Segall. Everybody, go listen to his podcast, Supreme Myth. Go support this podcast with a paid subscription, patreon.com/PeteDominic. I cannot thank you enough for all of it and look forward to a few more great conversations that I'll be posting for you to listen to, learn from, along with me later on today and this week. That's it. That's all. John Carroll has a new song out. If you haven't streamed it on YouTube, Union Made. Go check it out. There's a link in the show notes. He sings us in and out each and every day. Let's go.
When you can't see the forest for the burning trees, you got to stand up. Hey, you've been sitting so long, you got the creaky knees, you got to stand up. Stand up. I think you're driving wheels with leaking grease. Boy, you better stand up. Stand up. Well, there's a whole lot more of us who know what's right. They'll keep right on ignoring us if we keep sitting tight. You got to open up the window to let in some light. You got to stand up. That's right. You got to rise up. You got to stand up. You got to stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear when all you hear is a lie. So get up off of your butt, get down off of your fence. And even if it ain't a very friendly audience, well, they'll begin to listen when you start making sense. And you stand up, stand up. No need to point your rifle to defend your town. Just stand up, stand up. You know they can't deny you what you're laying down. Boy, you better stand up, stand up. Show your face of every color, yellow, black, red, and brown. She's the place where every lost child will finally be found. There's only one thing to do before we stand our ground, and that's stand up, stand up. Well, the founding fathers saw a land for all. They had to stand up, they had to stand up. They had a keen imagination for a crystal ball, drawing all the plans of stand up. But all they had to go on was the time they were in, with other causes for laws, and since they weren't even sin, they knew that change was gonna come before the change could begin. They had to stand up. All right, they had to stand up. We got to stand up. We got to look the devil square in the eye. We gotta let him know it's his time to go, and make it clear when all we hear is a lie. Why you lying awake wondering where the money all went? It'll be the cost of freedom that'll go unspent. You can see him flee the scene of that experiment if you stand up. All right, we got to speak up, we got to reach up and raise your voice in every way you know how. Don't be toes up, you got to show up. Ain't no better time to do it but now. No need to pledge allegiance to no wanton tribe. Rise up, show obedience to the voice inside, and listen well and it'll tell you not to run and hide. It says stand up, stand up. Oh, got to stand